the fires ignited by the court's Dobbs decision, are not dying down. Congress does have a few options pending. Is any of them at all promising? Any of them at all likely?
After the Senate Democrats put up the bill to codify the right to abortion, and it went down 49-51. I said, let's just put one out codifying the right to contraception. Make Republicans vote on this stuff. The coach who went to the 50-yard line and prayed, and he was and Gorsuch said he did in private, and Sotomayor put out in her dissent pictures of it, and he was mobbed. This court is, first of all, it's illegitimate, and secondly, it's disgusting. Alito, there was no reference at all to the 14th Amendment. There was no reference at all to why the debates about the 14th Amendment and the right to autonomy and the unenumerated rights that Casey and Roe were compromises.
Think about this. Not too long ago, you talk about the intersection of gun violence and violence in this country and Roe v. Wade, for example. The court really wants, and Congress was hoping to secure the protection of the members of the Supreme Court, because they don't think that anybody's choices, albeit intellectual legal opinions, but choices, to be controlled by anyone else. They want to be able, in a place like Texas, to have say over whether a vaccine enters their body, because that's about one's choice and their medical decisions. But when it comes to the agency and autonomy of a woman over her choices, over her wants, and over the balancing test that we have seen for really, in law school, we learn about this balancing test, the idea of your rights end where mine begin, and the states can take over versus the personal. That's really kind of gone now. The idea in Dobbs is the real crux of the matter, although they want to say that's not gone, but the real crux of the matter is, as long as history never contemplated this, or as long as history had a say, then the status quo should forever be maintained. Now, think about all the other areas where history had its say and society said that history was wrong. This is an open wound, but it's also an open invitation for states that not only to ignore precedent of the Supreme Court, for states to decide that the Supreme Court's rulings either shouldn't matter, as Texas did last summer, or for the court to decide, you know what, we're going to apply one logic here and forget about same-sex marriage or interracial marriage or same-sex relationships and relations. Forget about those. We don't mean those, but the logic would be the same. And it's just stunning time and time again to see how fragile these rights are. I mean, I woke up that morning when Dobbs came out with a certain set of rights. I went to bed that night with less rights than my mother, my grandmother, and my great-grandmother had. And I'm a Black woman in America. I went to bed with less rights than prior 2 generations had, all because someone said, you know what? History really had this issue pegged differently. So forget it.
The 2 major historical associations in the United States, including the American Historical Association, condemned the Dobbs decision for utterly misusing and distorting history. Sam Alito is a scoundrel, and no opinion by Alito can be taken at face value because he misuses data and turns it to whatever ideological viewpoint he wants. And of course, it's not just him, because 5 others signed onto that.
Is there even the most remote chance, if, even if you posit a couple gains in the Senate, might we see a legislative response directed toward the court itself?
I had Congressman Sheila Jackson Lee on my Sirius XM show the other day, and she pointed to the idea of increasing the number of Supreme Court justices based on, in part, what you both were speaking about. the perceived illegitimacy of the court, the idea of public opinion and public trust now not believing that the Supreme Court is as apolitical as it's supposed to be. The idea that the process to confirm obviously is very political, but now people are viewing the court with an increasing level of trepidation and mistrust that they really are not a political extension of the executive branch. We know that elections matter. And for that reason, some of the ways people are talking about these issues now is to perhaps expand the court and maybe impose term limits on the court so that there can be the transition of power. And I think about how this very argument haunted, in some respects, politically, now president, but then candidate Joe Biden, when he had to have the commission for the Supreme Court to sort of kick the can down the road about what is pejoratively called this court packing scheme. And I'm thinking that's rearing its head again, because people are wondering what Norm and Al are talking about. If it is illegitimate, how do you counteract it? Is it more justices? Is it a term limit? Is it the expectation of turnover so they're not as powerful? What is it?
There's another way to do this as well, and that is to change the jurisdiction of the court. The court has very limited original jurisdiction, and then there's appellate jurisdiction, but the Congress can set what the jurisdiction is of lower courts as well. If this continues, and especially as we get to the independent state legislatures theory, if there is a direct challenge there, cut their jurisdiction back. You can take away their jurisdiction and the jurisdiction of appellate courts on elections and voting. If you use the logic of the independent state legislatures doctrine, Congress has the authority over the time, manner, and place of federal elections. So there are a number of ways in which you could get at this, except that, getting back to where we started, you're not going to do it unless you have probably more than 52 Democrats in the Senate. And just as you've had the term pro-life hijacked, the term court packing has been hijacked. Mitch McConnell did the court packing. Enlarging the court would be restoring the court, not packing the court.